Good afternoon, everyone. I would like to call to order this public hearing of the Committee on the Judiciary and Public Safety. I'm Councilmember Brooke Pinto, representing Ward 2 and Chairwoman of the committee. The time is now 12:19 p.m. on Monday, June 17th, 2024. We are conducting this public hearing in person in room 412 in the John A. Wilson Building and streaming on the DC Council's website and YouTube at CM Brooke Pinto. On the agenda today, we have first a cluster of bills proposed by the Uniform Law Commission, or ULC. ULC provides states in the District of Columbia with nonpartisan and well-workshopped legislation that aims to clarify, regularize, and stabilize critical areas of state statutory law and to facilitate the proposal of uniform laws to the district. The 6 ULC bills for today span issues related to trusts, estates, and probate, civil remedies for survivors and victims of revenge pornography, and receivership in commercial real estate. They include Bill 25-219, the Uniform Powers of Appointments Act of 2024, Bill 25-224, the Uniform Trust Decanting Act of 2024, Bill 25-225, the Uniform Directed Trust Act of 2024, Bill 25-484, the Uniform Civil Remedies for Unauthorized Disclosure of Intimate Images Act of 2024, Bill 25-485, the Uniform Commercial Real Estate Receivership Act of 2024, and last, Bill 25-486, the Uniform Community Property Disposition at Death Act of 2024. We also have a bill concerning estates and probates, but which is not a ULC bill, which is Bill 25-538, the Strengthening Probate Administration Act of 2024. Let me say a few words about these bills, starting with the 3 bills related to our laws governing trusts. Bill 25-219, the Uniform Powers of Appointment Act of 2024, would clarify and codify common law regarding powers of appointment. Appointments to refer a non-fiduciary third party who acts alongside a trustee to oversee property distributions from a trust. This bill would clarify rules around creating, amending, revoking, and exercising powers of appointments in wills and estates documents and procedures. Bill 25-224, the Uniform Trust Decanting Act of 2024, would clarify and codify the rules and limits on a trustee's power to decant assets held in trust. Decanting is a technical term which means to pour assets from one irrevocable trust into another. Irrevocable trusts are those that cannot be altered by the settlor who establishes the trust. Trustees decant for a variety of reasons: to address unanticipated circumstances, to fuse trusts, or to protect trusts' adverse tax consequences. For example, let's say someone establishes a trust for their daughter, the beneficiary. If the daughter becomes disabled, some of the trust might need to be decanted into a supplemental needs trust to take care of her in order to safeguard the settlor's intent that the trust benefit the family member. This bill would also impose limits on a trustee's decanting of a trust in order to safeguard settlor's purpose and beneficiaries' interests while admitting of flexibility. For example, a trust dedicated to charitable interests could not be diminished or exterminated through decanting. Likewise, a trustee would not be able to decant from a trust without notifying the trustee and ensuring that the trustee's interests must be protected. Last, successor trustees would be protected from liability for past decantings of prior trustees by being able to take those past decantings as valid. Bill 25-225, the Uniform Directed Trust Act of 2024, would address the rise of quote unquote directed trusts and would clarify and codify the role of and rules governing trust directors. Directed trusts are a special legal entity that have both a trustee and a trust director. Director is a technical term here. A director is someone who directs a trust or trustee, but who is not themselves a trustee. This bill would also amend current law to add a legal clarification allowing trustees to distribute life insurance proceeds through a trust. This clarification would avoid potential jurisdictional and legal conflicts that arise when defining an insurable interest and insurable life for trust administrators. The next bill on the agenda is on a very different issue. Bill 25-484, the Uniform Civil Remedies for Unauthorized Disclosure of Intimate Images Act of 2024. This concerns civil remedies for victims and survivors of revenge pornography. The bill would create a civil cause of action for victims of unauthorized disclosure of private, intimate images, allowing them to recover damages. The bill would also authorize courts to grant a victim attorney's fees and other relief and would establish procedures to enable victims of such disclosures to protect their identity in court proceedings. Since this bill was originally proposed by ULC as a civil complement to our criminal statute on revenge pornography, I will be interested to hear about whether this bill still holds true after my Secure DC Omnibus was passed earlier this year, which modifies our criminal statute on revenge pornography to close a legal loophole. I will also be interested in learning of ways to expand this bill to incorporate my additional concerns over the rise of deepfake pornography, otherwise known as non-consensual AI generated intimate images, which continues to disproportionately harm women, girls, and femme people in particular. Next, we have Bill 25-485, the Uniform Commercial Rent Real Estate Receivership Act of 2024. This bill would clarify and codify common law regarding receivership for commercial real estate. A receiver is a court-appointed individual taking possession of or management over another person's property. For commercial real estate, a receiver is appointed when there is litigated property that must be maintained during a lawsuit, when an operating business needs to sell its assets efficiently, and upon request from a creditor with respect to a defaulting or insolvent debtor. Although this bill concerns commercial real estate, I'm especially interested in the tangential implications of this bill on receivership with respect to other areas of property. As a member of the Housing Committee and as chairwoman of the Judiciary and Public Safety Committee with oversight of the Office of Attorney General, at the performance oversight hearing for the Attorney General this year, I expressed concerns over how victims of landlord abuses whose residencies go under receivership were often left in the lurch and in continuous need. Although this bill isn't directly connected to residential real estate and the Tenant Receivership Act, I'll want to ask about whether we should draw inspiration from this bill to develop legislation that could potentially help additional tenants across the housing continuum, as commercial real estate is often converted into residential real estate. Our last ULC bill concerns probate issues. Bill 25-486, the Uniform Community Property Disposition at Death Act of 2024, would clarify and codify the default rules concerning the equitable distribution of property. A minority of states in the US, about 9, follow a community property regime in which the married couple retains shared rights over the property. The district is not such a jurisdiction. However, when married couples relocate to the district who formerly inhabited a community property jurisdiction, there have been probate and estate planning issues upon the death of one or both members of the couple. In order to ensure that the district probate court and/or trustees properly recognize the community property status in the decedent's estate and the district to avoid potential litigation among the surviving spouses and heirs, this bill would set up rules regarding the equitable distribution of community property to allow the court to determine the character of the property when there is a dispute among heirs. The bill would also clarify how property is to be distributed when a couple mutually agrees to separate, provide a remedy for bad faith transfers, and provide rules for non-probate transfers to ensure the proper disposition of community property. And last, in keeping with the subject matter of probate, we will end today with a ULC bill, Bill 25-538, the Strengthening Probate Administration Act of 2024. This bill would streamline the legal and administrative procedures around probate for district residents and estate lawyers. Probate refers to the financial and other administration of a deceased person's assets and estate. First, the bill would streamline the appointment of representatives for decedents' estates by permitting experienced court staff to appoint a personnel representative or to send the petition to a judge for further review. Second, the bill would reduce the publication requirement for notice of probate to 2 weeks and in one publication. And last, the bill would create an electronic will registry to complement the recent passage of the Uniform Electronic Wills Amendment Act of 2022 and make the safe storage and filing of wills more accessible. Other changes include the expansion of the number of estates that qualify as small estates, one worth up to $80,000, the increase of allowable reimbursement rates for funeral expenses up to $10,000, the transfer of some small estates by affidavit rather than having to go to court, the increase of homestead, family, and exempt property allowances consistent with inflation, and a clarification of legal probate terms. I'm particularly interested in this bill as I am very concerned and interested to learn about additional ways to address and redress current challenges with our probate system in order to improve access and administration. I consider the improvement of our probate system to be an important access to civil justice issue. For today's hearing, we're going to follow our usual practice and hear from our public witnesses first, and then we will turn to our government witness, who is here, the chair of the DC Uniform Law Commission, Jim McKay. I will now invite our first panel of public witnesses, Thomas Hemmendinger, who's joining us virtually, and then Nancy Drain. If you could sit to the seat in my right and the first left on your left, Daniel Passon, Courtney Robinson, and David Cox. All right, we will start with Thomas Hemmendinger, Commissioner of the Uniform Law Commission.
Thank you, Madam Chair, members of the committee. I appreciate the opportunity to testify on this bill, and I also thank you very much for taking me out of time so that I can make a ULC Executive Committee meeting in a short time. I've submitted written testimony that highlights the advantages of this bill, the Uniform Commercial Real Estate Receivership Act. And I'd just like to point out a couple of things, if I may. It's an extremely useful remedy that preserves the value of commercial property, but as the chair has pointed out, there isn't a lot of guidance on this, at least not a lot of modern guidance in the case law. And this act would solve that problem and fill that gap and tell litigants in courts what the court and receivers can and cannot do. The chair had also expressed some interest in the effect of this act on residential tenants, among others. And I'd just like to point out a couple of features of this act. It would cover, for example, an apartment building. So the court could put an apartment building into receivership, but the receiver would not be able to reject a lease to an individual who uses that apartment as their primary residence. So the receivership would not be able to throw somebody out or change their rental terms on them involuntarily. There's also a provision that protects people who are buying property under a contract for deed, which is not particularly common in many jurisdictions, but does occur. And that's a situation where the buyer makes installment payments while they're renting the property. And then when they've reached the purchase price, they get a deed from the owner. This would allow a buyer under a contract for deed to either treat a rejection of that contract as a termination of the contract, and they would have a lien on the property to protect their interest to protect their payments in the property, or it would allow them to follow through with the contract and compel the receiver to complete the contract once they satisfy all the payment obligations. With that, I'd be glad to answer any questions that you all may have. Thank you.
Thank you very much, Mr. Hemmendinger. Nancy Drain, Executive Director of DC Access to Justice Commission.
Good afternoon, Chair Pinto. Thank you so much for giving us the opportunity to testify today in support of the Strengthening Probate Administration legislation. We'd like to thank Councilmember Allen and his team for introducing this legislation, joined by you and 9 of your colleagues. And thank you and your team for arranging this public hearing. I'll just note that our judicial and courts commissioners did not play a role in the testimony that we will be delivering today. You have several issue area experts here today. I am not one of them. So I'd like to use my time to give you some background on how this legislation came to be. This is the culmination of efforts the Commission undertook in partnership with the Council for Court Excellence beginning in January 2020 to examine and strengthen the estate administration process. We recognize that this is a system that all district residents, regardless of their economic status, might need to navigate when they are experiencing the loss of a loved one. For many families, resolving probate issues is necessary to preserve home ownership from one generation to the next and to preserve intergenerational wealth. We also knew that it was a system renowned for its complexity, with very little legal support for low-income individuals and high rates of unrepresented litigants, raising real access to justice concerns. We established an estate administration working group that worked diligently for 2 years to develop a series of recommendations that were ultimately published in a February 2022 report. The working group was comprised of experienced probate lawyers, public interest advocates, and independent subject matter experts, and guided by the support of a technical consultant with deep local experience in these issues. DC Court's personnel participated in the working group and provided us with valuable input, but did not formally vote on its final recommendations. We are incredibly grateful for the dedication of this group. To develop an understanding of probate administration practices, the working group compared DC's procedures to other state practices, conducted an analysis of court records, and interviewed unrepresented individuals, probate lawyers, court staff, and other stakeholders. Probate law is largely driven by statute, which made legislative reform necessary to actualize a number of the report's recommendations. One of the primary drivers of the working group was to modernize a statute that had not seen a major legislative change in over 2 decades, since 2001. The working group was also informed by approaches employed in other jurisdictions that had proven successful in streamlining this complex legal process. And these legislative changes are again the subject of the legislation you have before you. We were also guided by the practical implications of the probate process, especially for low-income residents. How would these changes impact the average person facing the death of a loved one? How can we best ensure that their wishes are honored after their death? Are there ways that we can help people navigate these issues without having to go to court? What followed were a series of recommendations that we hope will address those concerns. We described these changes in plain language in our written testimony. Let me highlight a few. We will empower court staff to take some initial case actions in appropriate circumstances, reserving judicial resources for decisions that need judicial review. We will reduce costly and burdensome notice requirements while still ensuring that this important procedural requirement remains in place. We adjust a range of statutory dollar limitations to reflect the passage of time and better reflect standards in other jurisdictions in areas like what is considered a small estate, allowances, and the level of payment available for funeral expenses. We allow for certain low-value personal property to be transferred to pre-designated heirs without having to open a court case. I think one of the most essential aspects of this legislation. We promote housing stability by providing more time to seek the benefit of the homestead deduction, which is property tax relief for the principal place of residence. And finally, we create a new procedure where individuals can store an original copy of their will to ensure that it can be located upon their death. In addition to supporting this legislation, the Commission recognizes that we must also do all that we can to ensure that these types of cases receive the attention of legal services and pro bono legal providers to expand the availability of legal help. We believe that these reforms will not only make the estate administration process easier to navigate, but will make it a more attractive forum for legal services and pro bono attorneys to practice. Thank you again for the opportunity to submit this testimony, and we look forward to working with you and your team as we work towards markup.
Thank you very much, Ms. Drain. Danielle Passon, staff attorney at the DC Affordable Law Firm.
Good afternoon, Chairperson Pinto, and thank you for the opportunity to testify today. My name is Dan Passon, and I am a probate attorney with the DC Affordable Law Firm, also known as DCALF. DCALF plays a unique role in the district's civil legal services system. We deliver accessible justice to low and modest income district residents who fall in a justice gap between residents who financially qualify for traditional legal aid and those who can't afford to pay their own attorney. As the only district nonprofit representing probate clients in the justice gap, we support a unique group of clients. And in our 5 years of probate practice, our clients' novel, complicated circumstances have allowed us to see it all. Unfortunately, seeing it all has also meant seeing that probate does not work for district families, especially those who are less well off. That is why we support the Strengthening Probate Administration Amendment Act of 2023. We know that it will make probate cheaper, faster, and less intimidating, allowing more families to preserve more wealth. This is consensus legislation, that will make probate more navigable for every district family. We support the committee in marking up the bill this council period so that district families can start benefiting from it next year. In our written testimony, we discuss why this legislation will be transformative to district families. Today, however, I will focus on one small necessary addition that DCALF would propose the committee adopt. Onerous court costs rapidly diminish our loved ones' legacies. The committee can mitigate that by requiring the Probate Division of Superior Court to honor B25-489, the Expanding Fee Waivers for Low-Income Litigants Amendment Act of 2022, also known as the Fee Waiver Act. The heir of a decedent who is house rich and cash poor, like many native Washingtonians, is usually required to pay either $575 or $825 in court costs to access the wealth to which they're already legally entitled. Unfortunately, the probate division has construed its own rules to prevent litigants from receiving fee waivers and diminishing families' wealth by imposing a non-waivable judicial tax helps to ensure that poor residents will stay poor. The intent of the Fee Waiver Act was to expand access to justice by changing presumptive eligibility for the waiver of prepayment of costs to an absolute prospective waiver of eligibility throughout litigants' cases. The council was concerned that after waiving prepayment, district courts could attempt to recover any fees and costs later. It found this to be an unnecessary limitation on relief that undercut the goal of expanding access to justice. So the council struck all mention of the prepayment of costs from the district's fee waiver statute and required district courts to grant full waivers of payment to eligible litigants. Since the Fee Waiver Act went into effect, the probate division has not consistently applied the act to personal representatives, or PRs, of decedents' estates. According to the court, when someone petitions to serve as PR, any fee waiver the petitioner obtains is only valid until there is enough money in the estate to pay costs. So their own fee waivers only relieve litigants of the need to prepay, contrary to the plain language and intent of the statute. This practice is a substantial barrier to access to justice. The PR of an estate whose only asset is a home that her parents bought in the 1960s for maybe $5,000 may be required to pay $825 or more in costs. And it's more expensive for district residents to vindicate their rights in the probate division than anywhere else in Superior Court. It might cost $80 to file a complaint for absolute divorce or $120 to file a civil complaint, but it can cost $500, $800, up to $11,300 to probate an estate in the probate division. The court may object that requiring them to honor waivers could reduce revenue. Most litigants, however, are unaware that they can even apply for waivers. I've gone through hundreds of probate dockets, and I had never seen someone successfully apply for a waiver until I actually started filling them out myself. And if most of the clients represented by DCALF and Legal Counsel for the Elderly, the only other nonprofit that takes these kind of cases, were to start applying, and even if dozens of other people apply for waivers every year, we'd be nowhere near 10% of the 1,700 largest states that are probated in the probate division every year. Getting $575 from one litigant then may mean little to the court, but it means much more to the families who already have to hire accountants, title attorneys, appraisers, realtors who will take 6% of the value of an entire estate. That's to say nothing of the thousands of dollars in bond premiums, publication, and service costs families must pay. So we've submitted a proposed revision of this legislation that would require the probate division to honor fee waivers throughout and after probate. And as long as a low-income litigant served as PR, they could not be charged court costs. Thank you for consideration of our testimony. We look forward to working with the committee to strengthen probate, and I would welcome any questions the committee may have.
Thank you very much, Mr. Passon. Courtney Robinson, Counsel for Court Excellence.
Good afternoon, Chairwoman Pinto Robinson, and I am testifying in my role as co-chair for the.
Could you turn your mic on, please? Yeah.
Apologies.
No worries. I know it seems odd, but the TV can't pick it up unless it's on. So you can start over. We'll start your time over.
Thank you. Good afternoon, Chairwoman Pinto. My name is Courtney Robinson, and I'm testifying in my role as co-chair for the Council for Court Excellence's Estate Administration Subcommittee. CCE is a nonpartisan nonprofit organization with a mission to enhance justice for all in DC through research and policy analysts. And I'll note that in accordance with our policy, no judicial member of CCE participated in the formulation or approval of today's testimony. We've noted today already that the probate process is the legal process of collecting and distributing or administering someone's assets. And surviving loved ones can find that process very difficult, especially in an overwhelming and emotional time. As one self-represented individual we interviewed put it, it was hard to concentrate on the red tape when I was heartbroken. And another told us that the process was something that was horrible to them. They dreaded it because of the state they were in. They weren't in their right mind. They wanted things to flow. And the red tape made it harder. Unfortunately, few DC legal service providers are able to offer free legal help in probate cases. And we think it's important to ensure, though, that a deceased person's property is distributed properly with urgency to minimize disruptions for their dependents and other loved ones. That's why I urge you on behalf of CCE to pass the Strengthening Probate Administration Amendment Act without delay. Like many justice access issues, changes like this will benefit everyone while most deeply impacting people with fewer financial resources. In the District of Columbia, we know that economic inequity is also racial inequity, with Black and brown people being more impacted. And fortunately, this act aims to make probate more accessible and user-friendly for all of us. As our written and provided testimony details in more detail, I will just talk about a few of the key changes that the act suggests. First is streamlining the appointment of representatives for deceased people's estates. As many may know, the probate process cannot begin until there's a representative appointed for the estate. And currently, that process starts by having court staff, specifically the Assistant Deputy Registrar of Wills, review a petition for probate. Then that petition and their recommendations are sent to a judge for determination. The judge approves it. Then they issue letters of appointment that allow the representative to start taking action. Our working group through this act suggests speeding that process up by allowing those experienced court staff who have already evaluated every petition to decide in that moment whether to issue letters of appointment or to send them to a judge for further review. Another change in the bill that I'd like to highlight is that normally in your DC probate proceedings, you need to publish that probate has begun for 3 weeks with within 2 different publications. And we've estimated that for our average DC citizen, that takes about $400 of their monthly income out that they could be using for other necessities. And in context here, your TANF benefit for the smallest eligible household in DC is $437. So that is real money that a family who is already grieving would need. And by reducing the publication requirement to 2 weeks and in only 1 publication, we save a lot of time and money for those families. There's other aspects that we can highlight, including the creation of electronic will registry that would allow and provide safe storage for anyone who wants to file a will and make it easier to find wills when needed. Also expanding the number of estates that qualify for small estates, adjusting it so that instead of being capped at the $400,000 or $40,000 as small estates are defined in DC as of 2021, it would be increased to $80,000 to adjust for 2 decades of inflation and best practices. You mentioned in your introduction allowing the transfer of small estates by affidavit, and then also increasing the homestead, family, and exempt property allowances, again, to align with the inflation and with the Uniform Probate Code and other jurisdictions' best practices. And last, I'd like to highlight that the bill suggests an increase on funeral expenses to keep up with inflation, increasing that limit to $10,000 of funeral expenses that could be or taken on without court approval to meet actual costs. We are so grateful for your time and for the time of our fellow working group and the excellent staff that has brought these issues to the forefront and bringing DC closer to updating probate administration for the past, over the past 2 decades. And again, we urge you to pass this bill and happy to take any questions.
Well, thank you very much, Ms. Robinson. David Cox, public witness.
Thank you. Good afternoon, Chairwoman Pinto, and if there are other members of the committee participating remotely, so be it. My name is David H. Cox, and I'm testifying in my role as co-chair of the DC Estate Administration Working Group and co-chair of the Council for Court Excellence Estate Administration Subcommittee. As other members have testified, no judicial members of either were involved in drafting this testimony. I was proud to chair the DC Estate Administration Working Group that was designed to make recommendations to make probate a more accessible and efficient process for all stakeholders, while also creating a call to action for our legal community to invest more resources in serving people in these important cases. Those recommendations became the report titled Strengthening Probate Administration in the District of Columbia, the culmination of extensive research done immediately before the working group even first convened in January of 2020, and then proceeded throughout the intervening months, including through the COVID-19 pandemic. Dozens of interviews were conducted with experienced practitioners, court staff, self-represented individuals, bond issuing companies, local banks, title insurers, and many other stakeholders. Data on various other state practices were also gathered, helping to frame the recommendations made in this report. The DC Code drives much of the probate practice in the district, and thus some recommendations are meant for the DC Council, which has the authority to enact statutory change. That's what we're here to discuss today. In pursuing our legislative recommendations through the support of the excellent bill before you, we do so knowing that all members of our legal community, particularly the courts, the private bar, and the legal services community, are committed to ensuring access to justice for all DC residents. I won't enumerate again the various ways in which this bill would really help the probate practice in the District of Columbia, and I'll defer to our written testimony and the testimony of others. I am speaking to you today not just as someone who is interested in supporting legal services and self-represented individuals, although I do value those things. I'm also speaking to you as a long-term member of the private bar, former president of a DC-based law firm, chair emeritus of its real estate practice group, and member of the land title associations of the District, Maryland, and Virginia, and the American Land Title Association Title Council Committee. The changes put forth in the Strengthening Probate Amendment Act are good for everyone across the wealth spectrum. The last major legislative change to probate administration occurred over 2 decades ago, and I will shorten my remarks appropriately to note that it's time to make some major changes. I am grateful for the time and effort of Council Member Allen, Madam Chairwoman, and their excellent staff for bringing DC to the point of a hearing on these important updates to probate administration. Once again, I urge you to pass this bill for the benefit of all residents of the District of Columbia. Thank you for the opportunity to testify today, and I'd be happy to answer any questions after my colleagues have addressed all the specifics of these and the other critical components of the bill. Thank you.
Wonderful. Thank you, Mr. Cox, and thank you to all of our public witnesses and for all that you do every day on behalf of these clients who will be most affected. I want to understand kind of practically about how these changes would impact residents going through probate. How many cases do you currently see where people have legal representation when they're dealing with probate at all? And how many more probate cases do you think that we'll see in the coming years that this legislation will impact?
So I can tackle the first part of that question. I think on our research suggests that for about 97% of small estates do not have legal representation, and about 35% of your larger estates do not have legal representation. I don't know if anyone else on the panel wants to opine about what we think those changes would look like in the future, but that's kind of where the numbers stand right now.
That 35% number might not seem so bad. I mean, that suggests that 65% of people in large estates are represented. But our hope is that with the help of the heirs property legal assistance program through DHCD, DCALF, and LCE, we'll be able to represent more clients and get more people into court. Because the problem, or at least one of our primary challenges, is that we deal with properties that sit unprobated for decades and decades and eventually become heirs property, which is an unstable form of ownership, where family just lives in a house, but it never goes through probate, so nobody ever clarifies title or necessarily has an incentive to pay the taxes or care for the home. So there's currently about 1,700 large estate cases per year. There should be a lot more based on how much heirs property we see. And our hope is that through increased legal assistance and making probate less intimidating through these changes, we'll see more people come into court, and we'll just see more probate activity with the help of provisions like the transfer by affidavit provision in the law, which will allow people to avoid court altogether.
Okay, thank you for that. And as we think about a change like this going forward, which I hope it does, and we will work to get there. You talked a little bit in your testimony about the waiver applications and how people often don't even know to seek it out. So how are we going to expand our education to residents about waiver applications are about these types of changes that are going to make things easier for them. But when we already have a population that's sometimes difficult to reach when it comes to these matters, how are we going to improve those efforts?
If you look at the full report that we published several years ago, many of the provisions deal with legislative changes, and we've been focusing on those today. But the other half of recommendations all are around those issues that you describe. How do we increase community education? How do we just ensure that we have more legal services providers providing help? How do we improve self-help materials and other informational materials? So while we're focused on the legislation today, CCE and the commission and others have been working with the court to try to make improvements in those other areas as well. And we think that, that work combined with the streamlining that we'll see through the legislation will just make this a more accessible, easier to navigate process. But they really do go hand in hand. And I'm glad that you raised it because, of course, legislative changes are no good unless people don't know that they exist and that they're there to benefit them.
Thank you for that context. So the working group recommends changes to process, mechanics of probate administration, recommends changes to procedure, like reforms on how a decedent's property is treated, and to people and improving access to justice. So can you talk about how this bill would address those elements of the recommendations?
I can start. So I think a lot of the improvements to process come from the first couple of changes that we mentioned in the written testimony there, and that we've talked about in the panel, particularly streamlining the appointment of representatives. As I broke down during my testimony there are several steps that have to be taken before a person even has a representative over their estate. As a self-representing individual, those steps can be difficult to manage, and it's the first step in the process. Even as I've practiced law and been representing people pro se, those steps are difficult to manage as the attorney. So streamlining that process and having the very experienced court staff take that first step is one of the administrative ways that things could progress that are approached in the bill. I think the other part that impacts your everyday person, again, is the publication requirement. That takes out time. If you're reducing that publication requirement to 2 weeks, it also impacts people's wallets. It's less money to have that publication in one publication or a notice in one publication for a shorter period of time.
If I may just amplify, I agree 100% with the idea of administratively opening up estates. In our sister jurisdictions, you can get your letters of administration in a matter of days, like 1, 2 days, 3 days. That's not the case in the District of Columbia. And that delay just causes so much more harm down the road, particularly to the family that's involved. The other thing that this bill would do is increase the number of small estates. And one of the things we found during our research was that those who were involved, even if they were unrepresented, but if they were in the small estate category and it was a much simpler procedure, they actually reported a fairly good experience in that setting. So under this legislation, we would be increasing the amount of money that could be part of an estate that would still be small for purposes of administration. So I think as a really practical matter, that's going to have a really positive impact on the experience of people having to go through probate.
Mhm.
And if I could add just one other element,
Sure.
and that's the transfer by affidavit aspect of the legislation. This actually takes people outside of the court system and allows them to transfer personal property that's within certain dollar limitations without having to go through the probate process. You know, I was looking back at our report, and we have, stories from individuals who had to go through the entire court process to access $2,000, that was in the estate of their parent. And we're hoping that this transfer by affidavit language allows families to plan in advance to make these transfers seamless so that they can avoid the probate process entirely. And I want to emphasize that there are appropriate safeguards in the legislation to ensure that other individuals who might have a right to an inheritance, are informed prior to those arrangements being made. But empowering families to make these decisions outside of the court process is not just better for them, but hopefully will also, relieve some of the burden on the court to deal with some of those low dollar estates that really can be handled in a different way. And DC would be following many other jurisdictions that have these transfer by affidavit provisions already embedded into their laws.
Thank you very much for that. And speaking of safeguards, our probate process is too difficult and onerous now, but there are also safeguards in place to make sure that the desires of the deceased are honored. And so do you all, any of you have concerns about a potential for fraud with these changes contemplated? On one hand, making it easier, which is better, but also in a way eliminating some of the safeguards that are embedded in our current court system.
I don't, because we're not eliminating these safeguards. We're just streamlining them to make them easier to access. So if you look at notice and publication, we're still requiring that. We're just requiring it in a way that's more accessible to the litigants. When we talk to many other jurisdictions about some of these changes, like transfer by affidavit, but other types of changes, what they shared with us is that they did not experience the types of concerns with fraud that one might be concerned about. That they found that there were sufficient protections to be able to address concerns about fraud, but still, to really embrace these innovations to make the process easier. And let me just add too, one of the other provisions is the will registry. And I think that that's really critical to ensure, to your point, that the wishes of the deceased individual are honored. Many times wills are lost. They're hidden in a drawer somewhere. Lawyers don't store wills. They might for people like us, but often lawyers do not store wills for individuals. And so people are hiding those at home. They're putting them in places that the family can't find afterwards. And so allowing a safe place for people to store wills, I think will do the most to honor the wishes of the deceased individual and reduce the opportunities for conflict and disagreement among families after that death, which I think is not exactly fraud, but it's a form of that, really just not honoring the person's
Right.
wishes.
Thank you very much. Does anybody have a sense of how many direct legal service providers in the district are providing probate services?
So the DC Affordable Law Firm and Legal Counsel for the Elderly both offer estate administration services through the Heirs Property Legal Assistance Program through the Department of Housing and Community Development, and the Pro Bono Center through the DC Bar is also now up and running, and we will be establishing a probate litigation assistance network operated partly through the court, where we'll be able to offer some short-term legal services to people directly at the court on hearing days. So it'll be two main organizations that will provide ongoing representation: the Pro Bono Center, which will connect people with private attorneys doing pro bono work. And I know that Christian Legal Aid also does some probate work and connects people with private attorneys.
Thank you. So as I mentioned in my opening remarks, I'm also think about these issues kind of in their intersectionality with our housing needs. And as you have noted, the probate has interfaced clearly with other systems like DMV, tax, banking, title companies, bond foreclosure, a number of other issues. And so can you talk a little bit about ways in which that estates don't go through probate can worsen the district's affordable housing crisis?
If I may, your points are very well taken. I think a lot of people have been reluctant to probate their estate because of the complications, but also the money. And so what that leaves us with, unfortunately, far too often, are tenancy in common properties that ultimately become what we call heir property, because nobody has probated an estate of an owner for 25, 30, 40 years. And in the meantime, family members continue to reside there and think they own the property. But when there's an emergency or there's a fire, and then they try and get loans to try and fix that house, they cannot, because there is no chain of title to the current people who think they own the property. And that's because no estate was probated for the grandmother or for the grandfather. And this cycle just goes on and on. So I think whatever we can do to help encourage people to go ahead and open up and probate an estate, that is then going to clear title, minimize heir property situations, and provide people with the opportunity, if they need to example, pledge their property as collateral for a loan to repair a roof or repair the fire damage that was caused. So yeah, I think this bill helps encourage that.
Thank you very much.
This bill makes one more very important change that hasn't been highlighted yet, which is giving more people more time to apply for homestead to continue after someone passes away, and keeping homestead in effect for 6 months after someone's death. We see a lot of cases where properties end up in property tax sale for, so essentially someone will be eligible for homestead, maybe a cap credit, maybe the senior or disabled deduction. And when they pass away, the property is no longer eligible for that relief. When OTR figures out 4 or 5 years later that that property was not eligible for that relief, that property is going to get hit with a massive tax bill with penalties and interest for the 4 or 5 year period. And that can lead to a tax sale foreclosure, for which a year from now, there's going to be no homeowner assistance fund money to get people out of. So with half shutting down, I think this provision is especially important. And there's also an administrative fix that could be implemented in the future as well, which is to ensure that DC Health is communicating with OTR, so that when DC Health issues a death certificate, OTR gets that death certificate and a house is titled in the name of someone's heirs or in the name of the estate, not legally titled, but just titled on paper at OTR, so that we can not only see how much heirs property there is in the district, but heirs can be informed that they need to address what may be significant tax debt before a home goes into tax sale foreclosure.
Thank you very much for articulating that process. One of the things that I am very worried about, that I'm most hopeful about of this bill, is the raising the cap of funeral expenses. We have so many families in the district who cannot afford a funeral for their loved one. And a tangential challenge with that is we have our OCME's office, the Office of Chief Medical Examiner, taking on storage of many, many bodies of the deceased That is not the case in jurisdictions surrounding us or throughout the country. And so can someone speak to the kind of dynamic of funeral expenses as you've seen in your working with clients that this bill will help with?
I can speak to that. In my experience working with clients, I think the funeral expenses are, unfortunately, the expense that you're not thinking about immediately. It can sneak up on you. It varies depending on what that client or that person is looking for, what the deceased is looking for, cultural practices, religious practices. And what the act proposed today does is increases the limit that those kind of funeral expenses that a family could take on without court approval to $10,000. And just to highlight, in comparison to our neighboring jurisdictions, Virginia allows $4,000 worth of funeral expenses. Maryland allows up to $15,000. So DC has fallen behind in comparison to our neighboring jurisdictions, but the limit right now that was established in 1980 is at $15,000. That's the same buying power as about $5,685 today. So it's not giving families in DC the money that they would need or the flexibility that they would need to reach those expenses. And it's some of the first expenses that those families are going to incur during the probate process.
Wow, thank you very much. Okay, well, that concludes my questions for this panel. Really appreciate, as I said, your expertise in being here today and helping develop these bills, but also the work that you do every day on behalf of district residents. Thank you.
Thank you.
Okay, we are going to call our next panel of public witnesses. Mary Ann Franks, Judith Del Quadro Zimmerman. And if we could go in the same order, so Mary Ann to my right way, and then Judith here. Okay, great. Hello. Gianna Lynn. And Tina Nelson. Wonderful. All right, we will begin with Mary Ann Franks, professor and reporter on Bill 25-484 for Uniform Law Commission.
Thank you very much, Chair Pinto. My name is Mary Ann Franks. I'm the Eugene L. and Barbara A. Bernard Professor in Intellectual Property, Technology, and Civil Rights Law at the George Washington University School of Law. I'm also the President and the Legislative Director of the Cyber Civil Rights Initiative, the nation's leading nonprofit organization dedicated to combating image-based sexual abuse. I appreciate the opportunity to express my support for Bill 25-484, the Uniform Civil Remedies for Unauthorized Disclosure of Intimate Images Act of 2024. I served as the reporter for the Uniform Law Commission Drafting Committee that developed this Uniform Act. And in addition, I am a legal scholar who specializes in the intersection of privacy, free speech, and technology. I'm also a longtime advocate for victims and survivors of sexual exploitation and abuse. And these experiences inform my testimony before you today about the importance of enacting Bill 25-484. This bill addresses the increasingly common and deeply damaging form of abuse known as nonconsensual pornography, or the nonconsensual distribution of private, intimate imagery. Perpetrators of this abuse include former and current intimate partners, friends, coworkers, and complete strangers. Regardless of a perpetrator's motive or relationship to the victim, the unauthorized disclosure or threat of disclosure of these kinds of images causes devastating and often irreparable harm. This includes extreme psychological distress that can lead to self-harm and suicide, physical endangerment, including in-person stalking, harassment, and threats of sexual assault, and financial, professional, and reputational ruin. Victims have been expelled from their schools, fired from their jobs, and forced to leave their homes. Threats to disclose private, intimate images have been used to blackmail individuals, including children, into unwanted sexual acts, to coerce victims to stay in abusive relationships, and to gain leverage in divorce and custody battles. A 2000 nationwide study conducted by the Cyber Civil Rights Initiative found that 1 in 8 adult social media users has been victimized by or threatened with the unauthorized disclosure of their private, intimate imagery. The actual number of victims is undoubtedly higher when one also considers victims who are below the age of 18 and those who are not yet aware that their images have been distributed. Calls to the Cyber Civil Rights Initiative's image abuse helpline have increased nearly 150% over the last 5 years. The rise in this abuse and the increasing recognition of its gravity has led nearly every state in the United States, along with the District of Columbia, to enact criminal laws to prohibit it. These criminal statutes are important to deter this abuse, but they do not provide specific relief or assistance to victims. And that is what the Uniform Act is for. The act allows a person who has been harmed by the non-consensual disclosure of their imagery to bring a civil claim against the discloser. The relief that is made possible by this act includes the greater of either actual damages or statutory damages, punitive damages where appropriate, and recovery of an amount equal to the gain made by the defendant from the authorized disclosure if applicable. These economic remedies are significant given the wide-ranging financial costs associated with NDII, which can include counseling and other mental health support services, physical security measures, reputation management tools, job retraining, and relocation expenses. The act also provides for the recovery of attorney's fees, which is essential for victims with limited financial resources to spend on litigation, as well as for injunctive relief, which could include protective orders against further disclosure or that require the return or the removal of private content. To be liable under this act, a defendant must intentionally disclose or threaten to disclose a private, intimate image of an identifiable individual without the consent of the depicted individual, while knowing or recklessly disregarding the risk that the depicted individual did not consent to the disclosure, that the intimate image was private, and the depicted individual was identifiable. The act also includes important measures to protect the privacy of plaintiffs and to minimize the risk of further exploitation during the litigation process. The bill includes important exceptions to liability to ensure that the bill does not encroach upon First Amendment or other rights, including exceptions for disclosures made in good faith in law enforcement, legal proceedings, medical education or treatment, the reporting or investigation of unlawful or unsolicited conduct, and disclosures related to a matter of public concern or that are reasonably intended to assist the depicted individual. I urge the committee to report favorably on this urgently needed legislation. I thank you for your consideration, and I would be happy to answer any questions you might have.
Thank you very much, Professor Franks. Judith Del Quadro Zimmerman, public witness.
Good afternoon. My name is Judith Del Quadro Zimmerman, and I'm a managing partner of Del Quadro Zimmerman PLLC. In addition to my role at the firm, I have the honor of serving as the co-chair of the DC Bar Estates, Trusts, and Probate community. With over a decade of experience in probate law, I've dedicated my career to guiding individuals and families through often complex and emotionally challenging processes in estate administration. Our firm provides comprehensive legal services in probate and estate planning, and we pride ourselves on delivering compassionate and effective legal counsel tailored to the unique needs of each client. It is through this lens that we approach our support for the Strengthening Probate Administration Amendment Act of 2023, which we believe will significantly enhance the probate process for district residents. I want to highlight just a few provisions that I believe will have a very strong impact. Our firm strongly supports the creation of a will registry as outlined by the proposed legislation. We have repeatedly seen the distress and complications that arise when an original will cannot be located, when portions of a will have been lost or destroyed, and when there is confusion regarding the validity of the will presented. A centralized registry will mitigate such issues by providing a secure, accessible repository for storing wills, ensuring that they're available when needed. This innovation would also benefit practitioners by creating a best practice of filing wills in the registry, eliminating the frequent later confusion that we face of whether the original documents are in the possession of a law firm who drafted the documents or are in the possession of the decedent. We also support the increased limit on small estate administration cases. The adjustment reflects the economic realities of today and aligns with practices in other jurisdictions. A higher threshold for small estates will allow more families to benefit from streamlined procedures, reducing the need for formal probate, which can be time-consuming and costly. Our firm generally declines to represent potential clients who contact us for assistance with estates with a total value under $100,000 because the benefit of counsel is too costly for the value of the anticipated estate assets. The economics of running most private firms preclude private practitioners from taking on these cases. Nevertheless, community members who fall in this category need assistance to shepherd them through the estate administration process. This assistance can and should be provided by small estate specialists, which would close the gap of unrepresented clients in large estate proceedings. In conclusion, my firm and myself strongly support the proposed reforms that this legislation would bring to the probate process.
Great. Thank you very much, Ms. Quadro Zimmerman. Gianna Lynn, public witness.
Good afternoon, Councilwoman Pinto. My name is Gina Lynn. I'm a private practitioner, mostly concentrating in wills, trusts, and probating estates. I've been practicing probate law in DC and Maryland for about 30 years. I have a very wide variety of clients. Some of them have very few assets, some are middle class, and some of them are quite wealthy. Probate law can be a very rewarding field because we help families navigate through what can be a difficult process when they are in a time of great need. But it also can be very frustrating because many times the system appears to be more complicated than it needs to be. And we hope this legislation will simplify some of these complicated processes. I was asked to join the Strengthening Probate Working Group back in 2019. And as you heard from the previous panel, we had many, many meetings. And the report was very comprehensive and basically agreed to by most of the working group members. I'm just going to highlight some of the areas in the legislation that I think are particularly important. The first I would consider, the first most important provision, I think, is the transfer by affidavit provision, because this will allow individuals to transfer assets completely outside the probate process. And this piece of legislation was based on other jurisdictions. And it's interesting to note that California allows up to $167,000 to be transferred by affidavit. And Virginia has been doing this for quite a period of time, allowing $50,000 to be transferred. Our proposal is $40,000, which I think is reasonable. And the safeguard is that all family members would have to sign an affidavit saying they agreed to transfer the asset without a probate process. The second provision that I fully support is the issuance of letters by the Register of Wills Office. This has been going on in Maryland for a very long time. And as noted in our report, in Maryland, less than 1% of the cases require judicial intervention. One aspect that has not been discussed by any panel member so far is an amendment to what's called exempt property allowance, which is an effort by our committee to ensure that when adult children are disinherited, they don't receive what's called exempt property allowance. And the exempt property allowance would be increased to $20,000, but if a person making a will had disinherited their adult children, they the adult children would not still be entitled to receive their asset. And then the increase in the small estate limit, I also think is very important. As other witnesses have testified, this will free up court resources for other larger cases. And I didn't get to talk about the homestead deduction, but that's in my written testimony. Thank you.
Thank you very much. Tina Nelson, Senior Managing and Legal Aid Attorney at Legal Counsel for the Elderly.
Good afternoon, Chair Pinto and members of the committee. Thank you for the opportunity to testify. LCE represents clients going through the probate process in the District of Columbia. Navigating the process can be difficult for anyone, but particularly for low-income and self-represented parties due to the length of the process, the cost, and other factors. To address this problem, LCE recommends to the council that they pass the Strengthening Probate Administration Act of 2024. and I will highlight just some of the points of the act that are particularly significant to the clients we serve at LCE. The act increases probate efficiency by allowing court staff to issue letters of administration. Unfortunately, often seniors in crisis by the time they contact legal counsel for the elderly for probate representation. Many of the seniors that we represent find themselves at risk of homelessness because often the senior still lives in the family home and that home has never gone through probate. This makes clients ineligible for the homestead and senior citizen tax deductions, both of which are crucial to low-income clients' ability to maintain home ownership and remain in the communities because these clients are at risk of foreclosure. Any delay in starting the process to transfer title only exacerbates the problem. Currently, publication costs can run at approximately $370, which can be prohibitively expensive for low-income residents and seniors. These costs are often a barrier to initiating probate, leading to a myriad of problems down the road for legatees and heirs, including tying up properties for years. LCE supports reducing the publication requirement to 2 weeks and to 1 publication. LCE clients often do not have the costs necessary to open estates. In the past, LCE has upfronted these costs and established very modest payment plans for our clients. Recently, in the past year, LCE has been able to cover the costs for our clients through funds that we've received from a grant from DHCD heirs property. However, once those funds are gone, the cost will return to our clients. LCE also supports the creation of a wills registry in the district. For years, LCE has prepared essential life planning documents for our clients, including wills. When it comes time to probate estates, many seniors must proceed and testate because original wills cannot be located. This creates numerous issues, including potentially thwarting the intentions of the testator and unnecessarily creating heirs property issues when there's no will to distribute property to named beneficiaries. And in addition to the problem of lost wills, creating a wills registry will also address the common issue of petitioners who only have copies of wills when it comes time to probate estates. Overcoming the presumption that the will has been revoked or destroyed takes an enormous amount of time and resources, such as tracking down witnesses to the will, which for many of our senior clients are often deceased, preparing affidavits, seeking the cooperation of family members and heirs, and writing memorandums of law to the court to allow a copy to be admitted to probate. And if a copy fails to be admitted, then the probate has to proceed either through a longer, more complex standard probate process or through intestacy. A recent client we represented only had a copy of his mother's will. The family searched through her belongings, but were unable to locate the original will, and the original attorney who had prepared the will had long since retired. Because we were unable to locate the witnesses to the will, and due to the acrimonious relationship between the family members and heirs, unfortunately, LCE was not unable to proceed with this case. And the decedent estate remains in limbo, and the property continues to be titled in the name of the deceased homeowner. The client who currently lives in the family home is not able to obtain the homestead exemption or the senior citizen exemption property taxes, which would greatly reduce their tax burden on his limited income. Had the client's mother been able to securely register her will, her family would not have to endure years of uncertainty and housing instability. Many LCE clients are also seeking to probate modest estates, primarily access to bank accounts. And so we support increasing the amount of small estates from $40,000 to $80,000. We also agree that allowing certain estate assets to transfer through affidavit is a great idea. Removing some personal assets out of the probate process, such as transferring death deeds, payable on death bank accounts, insurance and retirement policies just makes sense. We have one story where we had a 6 to 8-year-old client who lost her last sibling and who only asset in his estate was a 15-year-old vehicle. And she tried for over 2 years to get title change, but wasn't able to do so. So she was actually forced to eventually open up a small estate to get access to that only remaining asset. And so these proposed changes will allow for an easier transfer of generational wealth between low income and moderate income families, which mostly stabilizes the family and the community. Thank you for the opportunity to testify, and I look forward to answering any questions you might have.
Great. Thank you so much, Ms. Nelson. Thank you all for being here and Similarly, as I said to the last panel, thank you all for the work that you do in this very important space. I want to start with you, Professor Franks. You are an expert in technology and free speech, civil rights, including image-based sexual abuse and technology-facilitated harms like deepfakes and other digital forgeries. You've also evaluated this bill for ULC and provided expert feedback to committee staff on these issues. And so I want to first ask you about the district's current criminal code for revenge porn, and then about this ULC bill and ways of possibly expanding to address the uptick in other types of deepfake pornography.
Thank you for the opportunity to speak to that issue. Starting with the criminal statute, I would note that there are, I think, fairly easy ways to amend the current criminal statute to address both currently authentic non-consensual pornography as well as synthetic. I do want to say at the outset, though, that one of the differences between the ULC civil statute and the criminal statute in DC, before we get to the synthetic question, has to do with the requisite mental state. That under the ULC bill, that it is only knowledge or reckless disregard for consent, privacy, and identifiability. That it's my understanding that in the current criminal DC statute for non-consensual pornography, that it's limited to those who intend to harm or who are acting with a financial motive. And so that is one thing that I think is keeping the criminal statute right now from accessing many of the cases that we see. About 79% or so of perpetrators of this abuse admit that their reason for engaging in this abuse is not about a personal agenda against the victim, but have some other motive. One of those motives is financial, but sometimes it's simply because they think it is entertaining to do so, or they're hoping to get some sort of social or other validation. So I wanted to mention that as a distinctive point between the criminal and the civil proposed statute. And one other piece I think that is important for the criminal statute that will relate to both synthetic and to authentic imagery is the currently existing Section 230 language that is in the criminal statute, which is different from the 230 language that you see in the ULC proposed bill. Namely, the exclusion currently in the criminal statute for DC says that there should be nothing in this chapter that will be construed to impose liability on an interactive computer service as defined by Section 230 for content provided by another person. And I'm aware in other jurisdictions that the reason why this language has made it into the statute is because representatives of the tech industry have indicated that this is necessary for to comport with currently existing federal preemption law when it comes to interactive computer services. But the phrasing of this is actually goes much farther than the current Section 230 language. And as you may be aware, Section 230 itself may be amended or repealed fairly soon. But even if it were not, Section 230 does not currently, in fact, require that you cannot impose liability on an ICS. There are many situations in which you are allowed to impose liability on an interactive computer service provider for the actions of others. And so I just wanted to note that that is one that will be both a problem, I think, for current authentic non-consensual pornography issues, as well as any differences for synthetic. The way that I could see that you could adjust the current criminal statute and or the civil statute with regard to capturing synthetic as well, I believe would be to change the definition of intimate image, namely to say that it would not only be images that depict a person's genitals or their nudity or engage in sexual conduct, but to include language that says or appears to be virtually indistinguishable from an authentic depiction of such. I think if those changes were made, that would be probably enough. There might have to be a few other tweaks made, but that might be enough. And I would say here as a point to underscore, because other jurisdictions have been struggling through this issue, I would advise against any language that says something along the lines of would appear to a reasonable person to be authentic. The reason why I caution against that is because we know in many of these situations that it is known widely to the public that the image itself is fake. So for instance, with the Taylor Swift fake news that were distributed some months ago, it was quite clear to the reasonable person or the average person that this was not in fact an actual depiction of the person that was claimed. That didn't make the imagery any less harmful. And so I would recommend that something like language like virtually indistinguishable from be used.
Thank you so much. That's really helpful. And this bill has been talked about as a civil complement to our criminal statute. As you know, in our Secure DC omnibus that I introduced and the council passed earlier this year, one of the changes that we made was to modify the district's criminal statute on non-consensual disclosure and publication of intimate images, known colloquially as revenge pornography. Specifically, we heard at the time worries that our statute had a loophole that was making it difficult to prosecute cases against perpetrators, since the standard was that a prosecutor would have to show that there was a quote agreement or understanding that these intimate images not be shared, which was very difficult burden of proof to meet. And so we changed this to focus on the perpetrator's mental state, the state of knowing or reckless disregard, in order to close that loophole. But in the uniform law, we have similar language to the updates that we made in Secure DC, but it goes a step further. For example, our criminal statute requires a showing of intent to harm, whereas the civil bill before us does not include that language. And so this tells me there might be a further potential loophole in our criminal statute that we initially missed. And so do you have thoughts on showing an intent to harm specifically in a criminal context, or what effects that would have on the burden of proof?
Yes, and I do appreciate that the amendment that was made that moved away from the agreement language to disclosing the knowing or conscious disregard for the risk that the person did not consent, I think is a very strong change. Yes, so the remaining issue would be that there is still the requirement that there either be an intent to harm the person depicted or to receive financial gain. That yes, we have seen that some jurisdictions have chosen to require that kind of showing. But as we have seen in our work, that it is largely, in fact, in most of the cases that we have looked at, that it is not someone who is actually intending to harm the person, but is rather maybe disregarding their their welfare altogether. And so I think that the best, if possible, amendment that could be made to the criminal statute for the purposes of addressing this issue is to remove the reference to intent to harm altogether. There are other ways that you could continue to have some reference to harm if that was necessary, that would not require the actual intent. But as we of course know in a criminal statute, if it's made into an element of the offense, that means that there has to be proof beyond a reasonable doubt that that was why the perpetrator acted to do this, which is incredibly hard to prove even in cases where we're talking about angry or vengeful ex-partners, but is going to not be the case when we're talking about a revenge porn site owner or a stranger or a hacker or someone else who has no relationship whatsoever to the victim.
Thank you. So this happens kind of in a lot of different contexts in our system right now in our country, where different states often have different laws, and there is sometimes a need or a benefit of having a federal standard. But as we've seen in other spaces, like with privacy, we can't wait for the federal government to catch up before we have our own protections. But what have you seen in the other 9 states that have adopted similar legislation? Have there been any challenges either within that locality or given the complicated nature of the internet that by nature always crosses jurisdictional lines but hasn't really been appropriately regulated federally?
I will say that the issue that you're highlighting is one that has concerned advocates in the space for some time. The first attempt to suggest federal legislation to address this issue precisely because of jurisdictional questions and definitional diversity, I think was first introduced in 2014. So for almost a decade, we've been trying to get Congress to pass legislation that would give us one uniform definition that would apply across any jurisdiction in the United States. The current version of that legislation is known as the SHIELD Act. It has been introduced. We are hoping that there will be a vote on this. I will say that in 2022, in the Violence Against Women Reauthorization Act, there was a version of something very similar to the Uniform Law Commission's civil provision that was adopted into federal law. So there is now a federal civil remedy provision. The restrictions there, of course, that it has to happen within interstate commerce, and so would not speak to every issue, but we do have language there. And that language does track the knowing or disregard, reckless disregard language you see in the Uniform Act. To my knowledge, there have not been constitutional or other challenges brought against the civil provisions in the 9 states that have adopted the ULC's Uniform Act. There have been constitutional challenges to various definitions of the criminal statutes. Most of those have resolved around the question of intent to harm. And so the very question that we have spoken a little bit about before, But I am glad to be able to say that in every single one of those challenges where this criminal statute was challenged on First Amendment grounds for having no intent to harm requirement or only requiring that there be a lack of consent, and every one of those cases where the case reached a state Supreme Court, all of those statutes were upheld as against First Amendment challenge. And I think with the same, that it's quite clear now that we have uniformity on this issue, that that is the strongest and best and most constitutionally permissible way to deal with this problem. And that the alternative, in fact, the requirement of only financial gain or intent to harm would actually raise constitutional issues, because the First Amendment does have there's a longstanding recognition under the First Amendment that you cannot single out certain improper motives. That is to say, if you have one form of speech that is done for a good or benevolent purpose and the same form of speech is done for a bad purpose, very often if you have a law that makes distinctions on that basis, that you will find yourself being challenged on the grounds of violating viewpoint neutrality. And so I think for that reason as well, it would strengthen this bill's constitutionality to remove the intent to harm element.
That's so fascinating. Go broader to be more constitutional. That's a rare balance. Okay. Well, thank you very much. I really appreciate that and appreciate all of our public witnesses for being here today. And be sure to send us, if you haven't already, your full written testimony so we can have that for the record. Thank you all. Okay, we are going to call our next panel of public witnesses who are joining us virtually. Suzanne Brown Walsh, Santiago Lacados, and Philip Evans. Please, as a reminder, to accept your invitation to join as a panelist. Okay, we will get started with Santiago Lacados, Commissioner for ANC 1B. Commissioner Lacados, please go ahead when you're ready.
Good afternoon, Councilmember Pinto. Thank you for the opportunity to testify today. As you said, my name is Santiago Lacados. I'm an ANC Commissioner Ward 1, and as well as in my professional work, an online trust and safety professional. I'm going to caveat, I'm testifying today in my personal capacity. My views don't represent those of my employer. I'm testifying in support of Bill 25-484, the Uniform Civil Remedies for Unauthorized Disclosure of Intimate Images Act of 2023. As you know, the bill would create civil remedies for survivors of unauthorized disclosure of intimate images, and would help bring the district in line with other states who have similarly adopted this language, and help protect survivors of intimate image-based abuse. And very importantly, as Professor Franks just noted, this bill would establish reckless disregard as a standard for civil actions and for non-consensual pornography, which, as I'm not going to duplicate her testimony, explain it much better about why that's a much better barrier in terms of dealing with situations of abuse. But I'm additionally here today to ask the committee to consider standalone legislation to combat the massive rise of non-consensual synthetic intimate image-based abuse, sometimes referred to as deepfake porn. I was at this committee earlier last year during the hearing on the Flash Act to raise this concern. But since then, and to be clear, not due to inaction by the committee, but the scale of synthetic image-based abuse online has been astronomical. Research that I've conducted in a previous role showed that the services offering the near instantaneous creation of non-consensual synthetic intimate images, or what they colloquially refer to as nudified or undressed photos, has skyrocketed in growth from nearly no websites, no users, and around the time of that actual hearing to around 25 to 28 million monthly unique visitors. The scale of this abuse is massive. In some context, what these services offer in terms of scaling abuse is disturbing. In many types of services, an abuser can upload a clothed photo, say a screenshot from someone's social media profile, or a picture posted to them at a work event. In seconds, these types of services edit the photo using image diffusion models, creating photorealistic synthetic nude images, which the abusers are then able to share. This has led to countless of cases, especially those that have more been publicized in middle and high schools, where those images are shared and used to harass and abuse female students. Another similarly used service survivors have their faces digitally superimposed onto real pornographic videos, and then said videos can be easily distributed for the purposes of harassment. But there have been more and more cases of both both of these being used as vehicles for harassment, especially not just individuals, but also politicians. In the district, in all of these cases, the survivors lack specific legal recourse targeted at synthetic content, including against their abuser, and then also the generator of that non-consensual synthetic content. I'm happy to discuss this outside the hearing, but also here as well. And I do want to thank Eloy Rodriguez Labrada and your staff for working with me on refining language on that legislation. And thank you so much. And I'm happy to answer any questions.
Thank you, Commissioner. Philip Evans, public witness.
Good afternoon, Chairman Pinto. Thank you for the opportunity to testify today. I'm a partner at Holland & Knight. I've been litigating the commercial space for approximately 30 years. I've handled a number of actions on parties seeking receivers as well as representing the receivers themselves. I testify in support of the Universal Commercial Real Estate Receivership Act of 2024. I believe this legislation will be great uniformity and structure in the District of Columbia. It'll be a benefit for advocates, the judiciary, and non-interested parties as well. I heard your earlier concern about how this might impact, say, tenants or other parties who are not sophisticated in the receivership process. I think this act, specifically with the claims process, the notice process, as well as the preservation of the tenants' rights to prohibit termination of leases, is one of the important aspects of it. And I would encourage the council to support this act and pass it promptly. Thank you.
Thank you, Mr. Evans. Under a minute, that may be a first.
About first.
Thank you very much. Suzanne Brown Walsh, Commissioner of the Uniform Law Commission.
Thank you, Chairperson Pinto. I'm Suzanne Brown Walsh. I'm a Connecticut commissioner, and just briefly, I'm here to support 4 of the Uniform Trust and Estates Act. I'm also a Trust and Estates commissioner, practitioner. The 4 acts are Bill 25-225, Uniform Trust Act, 25-486, Uniform Community Property Disposition of Death Act, updates one we've had on our books in Connecticut for many years. 25-224, Uniform Trust Decanting Act, which Connecticut just approved about 2 weeks ago. The last one's 25-219, Uniform Powers of Appointment Act. Just briefly, all of these, in my opinion, are non-controversial, wonderful acts to have on the books. They variously modernize or clarify trust and estate law, particularly the Powers of Appointment Act, where it's nice to have all of the rules that apply to those useful flexibility tools on the books. Trust decanting is the law of most states, either the Uniform Act or something that predated it. We do it whether we have a statute or not, so it's nice to have the rules codified, and these are a nice robust set of rules. Uniform Community Property Dispositions of Death Act is super handy if, as DC and Connecticut both are, non-community property states where sometimes people drift in with community property and we have to figure out how to address it. The Directed Trust Act is an incredibly handy piece of legislation in this day and age of teams of trustees, where one might have 2 or more trustees sort of each handling a certain silo of trust duties and a portion of the trust administration. So it's really nice to have a set of rules on the books that condone that practice, make it clear that the beneficiary isn't harmed by the practice, and generally allow professional trustees to better do their jobs in our jurisdictions. So I urge you to approve all these acts. Happy to take any questions, and thank you.
Great. Thank you very much, Ms. Walsh. I don't know if this experience can be drawn from Connecticut or any other jurisdictions, but do you foresee any challenges with the trust or the community property state being challenged, or where where the assets were generated. So let's say a couple moved from a non-community property state, then moved to a community property state for several years, then moved back to the District of Columbia. Would the question be where those assets were generated to determine if they qualified for community property, or would it just be triggered by having had ever lived in a community property state for a sufficient period of time?
You know, that's where we get paranoid in the non-community property stage, where I personally am afraid of community property. I don't want to blow it. And so what we typically do in our non-community property state is have the client sort of confirm this account was, originally community property, and we somehow address that in the title if they've moved the account from the community property jurisdiction to our jurisdiction. I don't think, I think it's the tracing, it's not the legislation that affects that.
Well, I can see that would certainly be best case scenario, but what in the event that the couple disagrees or has died? How do we reconcile which state to abide by if we're not simply looking at the state where the death occurred?
You're starting in this, so I'm no expert in community property. I don't deal with it a lot in Connecticut, but to me, my understanding of my role is one of tracing and recognition. So you're correct, we have to sort out what we can treat as community property. I confess I've never seen a dispute between spouses as to that. In my world, we normally want to make sure we've preserved the character of community property because it gets a double basis step up. So it's a tax reason, we like it. I have not been involved in a controversy involving it as a step.
Thank you. Commissioner, thank you so much for your dedicated work and advocacy regarding this really important issue around non-consensual AI-generated intimate images and your focus on ensuring that we do more in this space in the District of Columbia. I want to ask you kind of similarly to what I asked Professor Franks, since this bill does not include any language regarding deepfake pornography specifically, how would you recommend that this bill adopt such a provision to extend these remedies for victims of deepfake pornography? I know you talked about the need for standalone legislation, but we do have a bill before us that could be an appropriate vehicle to address this. And so what do you think about that, and how do you think that should be framed?
Yeah, thank you for the question, Councilmember. I would second what Professor Frank said in terms of specifically the language, allowing it to be, because one of the key points is that these are computer generated, but they appear photorealistic. So I'm not an attorney, so I'm not going to say exactly the best way to do it, but shifting the language just to include that aspect as well, that it not just have to be, an intimate image that is authentic, but that it can be something that is also, inauthentic. But I would really additionally, I know we do have this, I think tackling this legislation is a really good start. The need to look at it in the standalone legislation, just because the evolution of technology has unfortunately made the types of abuse possible so different than what I think our current law can handle, and also actually opened up ways where we can legislate at a local level, at the state level, to tackle it in ways that we couldn't do, with authentic images.
Okay, thank you. And do you foresee any loopholes in how this piece of the legislation we're contemplating today is structured?
Not as I read it immediately, but I would again then emphasize, unlike I think everyone else who testified today, I am not an attorney. I'm just very familiar with the law around the specific issue. But so as long as it is able to kind of cover, especially that reckless disregard, that's really important. Because and I'm going to keep leaning on Professor Franks' explanation because she did it much more eloquently than I did. She put it has a lot to do with just the high standard, and if this is sort of like in a civil action, having that was just really insurmountable. if there is not just a reckless disregard, if it was the criminal standard that we have now.
Right. Okay. Thank you. And lastly, do you have a sense, Commissioner, on the willingness of Congress to get involved in this space or other jurisdictions jumping in here, or is there still a unusual slowness and apprehension about that involvement?
I will say my reading from what I've seen in what I've read is what is happening in Congress is this is one of the few areas around artificial intelligence regulation that has sort of unanimous support. Or sorry, I'm not going to say unanimous. Very high unanimous. It seems relatively uncontroversial. I think at the local level, several states have already passed it. I think in the last year, even more are passing sort of the language is evolving because some of the previous laws didn't really sort of adapt for how the technology changed, because in the last year and a half, the technology has changed drastically. On Congress's side, I would have to refer to someone who maybe pays a little more attention to how things move procedurally. But my understanding is there's pretty overwhelming bipartisan support for something like this. And I Virginia already has a bit in their statute. It's not really elaborate, but other states, Illinois has a very good uniform statute on the civil side. There's other states that are kind of working and developing these as they go.
Great. Thank you. Well, we look forward to continuing to work with you and everybody on this panel. Thank you for your time and your expertise in this space. Appreciate you being here. Okay, that concludes our public witnesses for today's hearing. We are going to now turn to our government witness joining us today, James McKay Jr., the chair of the DC Uniform Law Commission. Welcome, Chair McKay. And as you may know, it is the tradition of this committee to swear in all government witnesses who appear before it. So if I can ask you to raise your right hand. Do you swear or affirm under penalty of law that the testimony you're about to provide before the Council of the District of Columbia and this committee is the truth, the whole truth, and nothing but the truth?
I do.
Great. Thank you very much. I'd now like to invite you to make any opening statement you may have.
Thank you, Chairperson Pinto. Good afternoon. As you noted, I'm James McKay, Chair of the DC Uniform Law Commission. And I thank you for the opportunity to appear today to testify in support of 6 uniform acts, which are the product of the National Conference of Commissioners on Uniform State Laws, otherwise known as the Uniform Law Commission. The District Uniform Law Commissioners are members of this national organization, which includes representatives from every state. Commissioners include private practitioners, government lawyers like myself, state legislators who are attorneys, law professors, and judges, both state and federal. The district has participated in the Uniform Law Commission fully as a state since 1905, 120 years. So the process of producing the uniform law is lengthy, exacting, and inclusive. Each is a product of years of work by a drafting committee of uniform law commissioners from several states. Each committee benefits from the expertise of numerous observers representing stakeholders from every perspective. Each act is considered at meetings of the drafting committee over the course of several years and is read at 2 or more meetings of the full Uniform Law Commission, which are held annually. After an act is complete, an organized effort is made to obtain widespread enactment by the state legislators. Having a Uniform Act has many advantages, including convenience and efficiency for individuals and organizations who are subject to different state laws, and also having a state-of-the-art law interpreted and explained in judicial decisions by courts throughout the country, and in law review articles and treatises. While I have been legislative liaison for the district, the council has enacted over 90 uniform laws or amendments to a revision of those acts. These acts are in a variety of areas, including family law, commercial law, business law, consumer law, election law, health law, real property law, alternative dispute resolution, and estate trust and probate. 4 of the 6 uniform acts before the committee today are in the area of estates and trusts. These acts would complement 2 major uniform acts that have been enacted by the council: the Uniform Trust Code, which has been enacted in its entirety, and the Uniform Probate Code, which has been enacted in most part. These 4 uniform acts in the area of estate trust and probate would greatly benefit district practitioners and the district residents who are their clients. I'll start with them. Bill 25-219, Uniform Powers of Appointment Act. Power of appointment is an effective and flexible estate planning tool. A good estate planning attorney can help a client plan to distribute wealth in accordance with the client's goals, but nobody can predict the future. The Uniform Act allows a client to avoid naming beneficiaries to receive specific property and instead to name a trusted third party to direct the distribution of property to the beneficiaries after the client's death, taking all future conditions into account. The Act provides clear statutory authority for the creation and revocation of powers of appointment. I think the other witnesses have given Commissioner Walsh, for example, good examples of why you would want to do that. You have perhaps grandchildren, you don't know who's going to be trying to go to college or professional school. You don't know what their future is. You don't know what their needs are when they're children. So this Uniform Power of Appointment Act would provide a solution to that common problem, and its adoption will be of considerable benefit to estate and planning practitioners who must draft enforceable provisions and will provide needed guidance to the courts in interpreting powers of appointment granted by wills and trusts. Bill 25-224, Uniform Trust Accounting Act of 2024, provides clear rules for trustees' distribution of assets from one revocable trust to another. It's like pouring wine from one vessel to another. That's why they use the word decanting. A decanting can be used for many purposes, including to address changed circumstances not anticipated by the first trust. Examples include conforming the trust to the requirements of a supplemental needs trust for the beneficiary who becomes disabled, reallocating funds designated for a particular purpose that are no longer needed for that purpose, changing the status of a trust, combining trusts for greater efficiency, and avoiding adverse tax consequences. The Uniform Act 1 provides clear statutory rules replacing often murky common law decisions. 2 provides appropriate limits on a trustee's ability to decant to ensure that the settler's intent is carried out. 3 protects beneficiaries by requiring notice and protecting all vested interests. 4 protects charitable interests from reduction or elimination. And 5 protects successor trustees from liability for a previous trustee's decanting by allowing them to rely on the validity of the decanting. The Act makes decanting safer and easier. Bill 25-225, a directed trust, is a trust that divides fiduciary powers and duties between a trustee and another fiduciary to whom the trust instrument gives power over some aspect of the trust administration. These types of trusts are becoming standard in trust drafting and are often necessary to ensure the efficient administration of the trust and to protect the interests of the beneficiaries. The Uniform Act accommodates this emergent practice by expressly permitting a trust to have a trust director. However, the division of authority between a trust director and trustee raises questions about how to divide fiduciary powers and duties. The Act provides clear functional rules which permit a trust director to have a primary responsibility and authority in the administration of the trust while maintaining key fiduciary protections for the beneficiaries. In general, the Act allocates future fiduciary duties to the party that has the power to act and relieves parties from potential liability for actions of others. The Act does not permit any reduction of fiduciary liability for action in the aggregate. Some party retains ultimate responsibility for each aspect of administration. The Act also provides sensible default rules for a variety of matters that might be overlooked in the drafting of a directed trust, including information sharing and accepting the procedures for accepting appointment as a trust director. In other words, the act provides clear rules for allocating duties among fiduciaries under the terms of a directed trust. The final of the four, Uniform Community Property Disposition at Death Act. 9 states and 2 territories comprising over 30% of the country's population are community property states, including the 2 largest states, California and Texas. Community property acquired by a married couple retains its character even after they relocate to a non-community property jurisdiction such as the district. This creates potential distribution problems after the death of the first spouse and potential estate planning concerns. A probate court or trustee in a non-community property state may not recognize the character of community property in a decedent's state, which could lead to a misallocation of the decedent's property and potentially to disputes between the surviving spouse and the decedent's other heirs. The Uniform Act provides a set of default rules to ensure the equitable distribution of community property in such a situation, which assists courts in determining the character of property when there is a dispute. The Act also clarifies the process for petitioning and reclassifying community property for couples who mutually agree to separate their interests, and provides a remedy to address bad faith transfers intended to impair the rights of one spouse. The Act also addresses non-probate transfers of community property. Thus, the Act provides clear default rules to ensure the proper disposition of community property from any state in any jurisdiction. Now, to turn to the 2 other Uniform Acts that are not estate and trust, the Uniform Commercial Receivership Act. A receiver is somebody appointed by a court to take possession of another person's property and manage it. Receivers of commercial real estate are used in a variety of situations, including one, when a property is the subject of a lawsuit and its value must be preserved during the litigation. 2, when the property includes an operating business to sell its assets in an orderly manner and maximize the return for its owners and creditors. And 3, when requested by a creditor to collect, preserve, and distribute the property of an insolvent or defaulting debtor. Presently, as you've heard from Pete Evans, the receivership law in the district is made by judges on a case-by-case basis. Every receivership case is unique, and in every such case, there are lingering questions about whether a broad appointment order from a court of equity can override other laws governing liens, debt collection remedies, and foreclosure procedures. The Uniform Act is designed to fill this legal vacuum and thus reduce litigation. It provides comprehensive rules regarding the appointment of and powers of commercial real estate receivers. In particular, the Act authorizes a receiver to use, sell, or lease receivership property in the ordinary course of business and to take such actions outside the ordinary course of business with court approval. The Act thus allows a mortgagee through a receiver to assume control of the mortgage property, operate the property as a going concern, and sell the property in an arm's length transaction. And in addition, the Act allows a receiver to conduct a unified sale of encumbered real estate and related personal property, such as equipment, franchise agreements, and intellectual property. This process will likely yield a higher recovery than a distressed foreclosure sale would, thereby benefiting both the mortgagee and the owner. Finally, the Uniform Civil Remedies for Unauthorized Disclosure of Intimate Images Act. As noted, it complements the district's criminal law criminalization of non-consensual pornography act of 2014, which also criminalizes the unauthorized disclosure of sexual images of another person. The Uniform Act creates a civil cause of action for victims of unauthorized disclosure of private intimate images. It provides for actual damages, statutory damages, punitive damages, and disgorgement of profits. Moreover, it authorizes the court to grant the victim attorney's fees and other relief, such as injunctive relief. It also provides procedures to enable victims of such disclosures to protect their identity in court proceedings. Just 2 comments. First, the comment on this letter you received from TechNet. The Act provides in Section 8 that it's be read consistently with the Federal Communications Decency Act of 1996. However, we strongly oppose requests that the committee has received from TechDeck asking to add provisions to the Uniform Act to address matters that are not germane to the Uniform Act and which would expand protections for internet service providers far beyond the federal act. The federal act, for example, does not immunize the use of the internet for sex trafficking or violations of federal law. And this proposal by TechNet would do that. We would strongly urge this committee not to adopt those changes. Another thing I would want to mention is deepfakes. Now, you have thought that this act might be a good place to put something about deepfakes. I just want to alert you that the Uniform Law Commission has appointed a study committee about a year ago on deepfakes to develop a uniform law on deepfakes. And I think Commissioner Walsh, who just testified, is the chair of that study committee. Under the process of the Uniform Law Commission, a study committee will recommend the appointment of a drafting committee, which in this case is almost a certainty. And then the drafting committee would draft a uniform act on, in this case, on deepfakes. And we would attract observers for every aspect of the issue to participate in the deliberations. I think the fact that we believe a study committee was necessary is because the question of deepfakes, and we're talking about two things, basically, the non-consensual sexual images, sort of like this, but these are obviously deepfakes. These are not the actual people. The second is the use of deepfakes in political advertising. Those are the two main problems that we have seen hearing from people all over the country about the use of deepfakes. And the Uniform Law Commission, as I said, has this project ongoing with a lot of, very interesting. Actually, the observers join at the study committee stage, so we are already getting the input from people throughout the country on the subject. I would suggest that you might consider waiting for us to give you a uniform act. You'll be the first one to get it on deepfakes, rather than trying to expand this. On the other hand, we'd be glad to work with you if you really wanted to do that. In other words, we have 6 uniform acts, as I mentioned in my opening remarks. The Uniform Law Commission, the district's been a member of the Uniform Law Commission since 1905 and has been considered a state fully for the last 120 years by that organizations. And the 6 Uniform Law Commissioners participate in the National Conference of Commissioners for Uniform State Laws. And all these acts were the products of very lengthy, exacting, and inclusive processes that took years, and we're bringing them to you with all the work that's going into it. And we are very in a very organized fashion trying to get them enacted through the United States through all the state legislators. So in sum, these 6 uniform acts will improve the district's laws in the areas covered by them to the benefit of district residents and businesses. I therefore urge the committee to report favorably on all of these bills. I would be happy to answer any questions.
Wonderful. Thank you so much, Commissioner. And I appreciate your testimony and your comments about some of my other comments made today. In terms of the deepfake working group, what is your expected timeline for that type of work?
Yeah, I do. I would think that we will probably, I can't, speak for the Uniform Law Commission. I would think that given the fact that this study committee has been going on for probably almost a year, I would think we'll have a recommendation. We have a meeting in July, and I would imagine we have a process. We have a scope and program committee, and they will recommend appointment of a drafting committee. Given the, I certainly will keep you up to date on that, but I would hope that if this is a problem that I don't know about, that a drafting committee will be recommended for appointment. It may not be chaired by the study committee chair, but it may be. And then we would start immediately working on a Uniform Deepfakes Act, a Uniform Act to address deepfakes, both in the area of political advertising and in the area of non-consensual sexual images. So I will keep the committee completely up to date as each decision is made on this ongoing project. But it is certainly ongoing, and we have a committee of probably 10 or 12 uniform law commissioners appointed to the study committee. We have observers, we have a reporter, and so it is an ongoing project that will be definitely in our focus in the next couple of years.
Okay, thank you. So let's spend a couple minutes talking about the Receivership Act. My understanding is that currently receivership law in DC, and you talked a little bit about this in your testimony, is common law based. So it's inconsistent. And this bill would regularize and codify our rules over appointment and powers of commercial real estate receivers. Can you articulate kind of what the rules and uniform standards are that this bill lays down in layperson's terms and what practical problems it would be addressing?
Well, it depends. Each receivership is unique. It's the Superior Court. There's no real appellate law on the cases on receivership in the District of Columbia. It's all done on a case-by-case basis by the Superior Court, and it depends a lot upon what the property is, who the creditors are. I mean, if you have an apartment complex, you not only have creditors, you have tenants who are living there. And you have to worry about a lot of people's interests when you're doing that. I mean, the problem is that if there's litigation involving a property, it very well could be, the only thing the owner can do is just board it up, and it's not producing any money or any economic benefit for the district, no taxes, and no rent, and no productivity. And the idea of a receivership is to maximize the use of distressed property, subject to litigation, for example, and to allow the receiver to make a productive use of the property, without changing the rights and interests of all the people involved. Like, obviously, the debtor is going to want to maximize the return from the property because otherwise the debtor is left holding the bag, basically. It's a difficult thing. I think Pete Evans, who testified, has handled a number of receivership cases in the Superior Court, and he tells me that the only way they are successful is that the Superior Court judge just follows the petitioner's lead. The petitioner tells the Superior Court judge what to do. So this is, as I said, this is, probably an accident waiting to happen. And I think the uniform law is going to maximize the return for the debtor and the creditor, and also make life easier for the Superior Court, who has to handle all these cases.
Thank you. Do you think that there is any inspiration we can draw from these changes in the residential context?
Well, as I said, it would. I think you have several ways to say in a receivership. You would protect the tenants. You would have to. You wouldn't. I guess you have a situation now. It's okay. The properties in receivership, we're closing it down. Everybody's got to find a new place to live. Well, that's very disruptive, and that's not very fair. Because the tenants didn't cause the problem. So a receivership allows a lot of flexibility on the part of the court, and the mortgagee will be able to basically operate the business in a way that's productive. And clearly, boarding up an apartment complex is not as good as getting rent. So I think that the problem is that the law is done on a case-by-case basis. And since we really don't have very many Court of Appeals decisions, really, there's no common law that's being developed. It just, if there is, it's very ancient. And this would be a statutory framework for conducting a receivership for the use of the property and its sale and rental and disposition. So I mean, this is an area of law that's really crying out for a statutory framework. It just doesn't have anything. We're all kind of, every receivership is a new phenomenon.
Okay, thank you. So let's talk about the trust and estates bills a little bit.
Sure.
With these three bills, I want to get some clarity on the practical problems that these bills are seeking to rectify and how DC residents would benefit from the passage of these bills. So the Uniform Directed Trust Act concerns directed trust and trust directors, which a similar law has been enacted in 16 states, including Virginia. And my understanding is that there's also been a rise of directed trusts nationwide without clear law on how to handle them. So can you provide some more clarity on how this law specifies the fiduciary duties of the trust director relative to trustees and
No.
how?
I'm sorry.
No, that's okay. I was just gonna say, and also if you can elaborate on how the bill allocates additional fiduciary responsibilities and duties between the director and trustee.
Well, Chairperson Pinto, this is a situation is that a settler, let's say a husband and wife, the husband would say, okay, if I die, my wife is going to be my personal representative, and that their children too. So the spouse, surviving spouse is a personal representative. The surviving spouse might have absolutely no business acumen or might not have any financial training. And so what the trust would do, or the will would do, is designate a somebody who does have like either perhaps be a law firm, could perhaps be a relative, who does have the necessary financial acumen in order to make business decisions. It could be they could be an ongoing property that the couple own, for example, and so the trust protector assigns to this expert the financial administration of the trust, but the actual personal representative is the spouse. Now, if there is a disagreement between the trust director and the spouse, then you might get into trouble. And this law is intended to prevent that from happening, to allocate the fiduciary responsibilities of both the trust director and the personal representative. And it could be, there could be hundreds of different situations, but right now we really don't have anything on the books that tell you what happens when things go wrong. And you have there are a lot of wills appoint trust directors, but there's no real, framework. Again, this is one of these bills that creates a needed legal framework for addressing a situation where there's a problem with the questions about responsibilities between the personal representative appointed by the will and the trust director also appointed by the will or the trust. It's as I said, these are areas that this framework is needed if there is a dispute, and of course you got a lot of dangers there. You've got maybe the will had charitable dispositions, and like the trust director wants to change that, and you don't, that can't happen. That would be prohibited. And then you've got the welfare. Let's say the spouses might have children. You have to worry about that too. So the point is that it's necessary to have a trust director when you have a situation where the personal representative doesn't have the financial expertise. And this basically allows both those fiduciaries to work together and coexist and provides methods to resolve disputes.
Thank you. Can you elaborate on, in layperson's terms, what the Chawla problem is and how this bill would rectify it?
I'm sorry, the what?
The
problem?
Chawla problem around insurance. Am I mispronouncing that? Chawla?
Which bill are you?
It's my understanding that around the directed trust, there's something that's kind of referred to as the Chawla insurance problem about inconsistent insurance.
Well, I could follow up with memo on that. I'm not an expert on insurance law, but
Okay.
I mean, this is a directed trust act, right? Well, we have I think we might have discussed that in the formal comments to the official comments to the Uniform Acts. I think discusses that. I'd be glad to follow up though with a memo, a follow-up memo about that. I don't really know.
Okay, no problem. Thank you so much. In terms of the Decanting Act, this bill has been adopted in 14 states, including Virginia. Can you talk about the practical problems that this bill will help with?
Well, trusts, get old. I mean, a trust, let's say created 40 years ago, and it had set aside $50,000 for the education of my grandchildren. Okay, 40 years later, they've all been educated, and there's all this money left over. What are you going to do with it? I mean, you might want to repurpose that money for something else, or you have a lot of situations. I think one of my looking at one of the example is you move one jurisdiction to another, and you have to conform to the special rules of that jurisdiction. You might have several trusts that were created, one by the mother, one by the father, and now you've got these two trusts, and you have to pay double fees. You have to do tax returns for each one. You have to pay administration fees, and you want to combine them for efficiency. And the idea is that trusts get old and the terms get out of date because of changed circumstances. I gave the example of you have a child now needs to have a disabled child, becomes disabled and needs supplemental needs more money, and the trust didn't foresee that, the original trust. And so the idea is that you can basically reform the trust without affecting anyone's interest, but in a way that's efficient and responsive to current conditions that perhaps were not foreseen when the trust was created 40 years ago. And so this is becoming very popular because of the need to do that in an inexpensive, efficient way. This way, again, this creates a legal framework to allow trustees to reform their trust by pouring the terms into a new trust, which is up to date and current and responsive, and yet it doesn't affect any of the underlying basic decisions by the settlor. So again, we're talking about irrevocable trusts because the settlor is dead, and we're trying to create a modern responsive trust to current conditions. Again, it's a legal framework that's sorely needed, and we don't have anything. And the other trust and state act is the disposition of property and the community property. That is the fourth Uniform Act, and that can really be a problem. And the practitioners in this jurisdiction don't really know very much about community property. And I've spoke to the chair of the DC Affairs, not the DC, the State Trust and Probate Community. He said, well, I don't deal with community property, and that's true. But a couple comes in from one of the biggest states in the United States, California, Texas, and they have community property, and one of the spouses die, and you've got a real problem because people under district law, especially because you don't have very many practitioners in the district who know very much about it. This would provide again, a legal framework for the equitable, fair distribution of community property from couples who acquired the property in a community property state, and it retains this characteristic as community property. So this one again would provide a very important legal framework for that, and will prevent litigation.
Thank you. How does this bill contemplate enforcement of charitable interests?
Well, I mean, of course, the Attorney General does have standing usually to protect against people trying to dissipate charitable interests, but the bill does. Let's see. Does, as I said, it provides uniform community property state. Well, I mean, I guess I mentioned there was a problem with charitable interests. That I think that was mainly the one of the other, several of the other bills dealing with charitable interests, like the trust to canning, or the but certainly the purpose of the Community Property Disposition and Death Act is to allow the equitable distribution of community property among spouses. I don't think it deals with charitable interests. Some of the other ones do deal with charitable interests, though, like I mentioned the Trust to Canning Act protects against reducing or limiting charitable interests. But I don't think the Community Property Act deals with that particular aspect.
Okay, perhaps that's something we can follow up with
Yeah,
the
I'd
Attorney
be glad
General.
to
Okay.
follow up with any questions you have.
So back to the communal property issue and the death at disposition, I raised this as one of our public witnesses, but do you foresee any problems of a more complicated case where a couple may have lived in Connecticut and then California and then the District of Columbia, and figuring out, do we determine their assets as though they earned all of them in a community property state, or tracking it down? Like how do we, this bill is meant to be increasing consistencies, but in an inconsistent environment, are we contemplating all of those unique scenarios?
Well, I'm not an expert in community property, but I think that a community property has to be acquired by the couple when they resided in a community property state. So if a couple resided in a common law state like the District of Columbia, that would not be proper community property. I think that would not be community property. But then let's say they go to California and spend 10 years there, and they acquire a lot of property there. I think that might be community property. And then they come back. I think, again, you're right. There can be really complicated situations here when people go from state to state. They go between a community property state and a non-community property state. But I think the bottom line is that if there is community property, I mean, the laws of the states determine what it is, and the couples do in many states have the authority to segregate their property. They can say, okay, we're making a decision, and in some states will allow them to keep their property separate to some extent. But if that doesn't happen, when you come back, this act would operate only when a couple who was at some point in their history resident of a community property estate and also acquired property in that community property state as a couple. And to the extent there is that sort of property and they come back to the district, district law would then apply, and the district law doesn't really tell you what to do. If there is, let's say, you have one spouse produces 90% of the income, and that spouse dies and has children from a previous marriage, and you can see the potential for a lawsuit there. And the question is how do you protect the interest of the surviving spouse in the community property of the deceased spouse? And that is what this act is intended to do. It's intended to deal fairly with the surviving spouse and avoid litigation, which of course could happen from the situation I mentioned where the deceased spouse has children from another marriage, and then you might have a problem. But this act, again, provides a legal framework to deal with situations that may arise, and it prevents bad things from happening. So it's a very, very well thought through Uniform Act. And as I said, we have 30% of the population in the United States lives in a community property jurisdiction, and the other 70 don't. But there's a need for this because there's no legal framework in the district.
Do you contemplate other jurisdictions that are not community property states taking on similar reforms in the next
Yes,
short while?
This act, let's see, I think testimony, the written testimony of Susan Wall shows a map of the United States that we are, there are, again, this act is only intended to be enacted in a non-community property state because it deals with the situation when a couple comes in. We had an older 1971 uniform community property states that 14 states have enacted. This act has just got, it's a very new act, but it's a really important act because it responds to a problem that people don't really think of it. You know, practitioners don't even think about the fact that somebody comes in from a community property state and what to do with the property if one spouse dies. I mean, it says apparently three states have enacted. It's been introduced in several other states where these acts do take a while to get enacted throughout the United States because they're not, really on people's number one list, but they're really important and to improve the welfare of residents of the district, including those who came in from community property estates, and to protect them from, having their property being taken away. I think this is a really important act, and it's one that is very well thought through by the experts in the country. It's not proven at all controversial like the other ones. So I would highly recommend it. I think it's important.
Okay. Well, thank you very much, Chair McKay. That concludes my questions for you today. If you have any closing remarks, I want to give you the chance to highlight anything we didn't have a chance to talk about.
Well, I just wanted to say thank you so much for holding the hearing on 6 uniform acts. I have, since I've been legislative liaison, the council has enacted, I keep a list, 91 uniform acts or amendments or revisions to uniform acts, and this would add 6 to that. And each one, I think is important, and it improves the law, the body of the law of the district, the substantive body of the law of the district, until we're really one of the best states in the country. When I first became a uniform law commissioner, they had a map of the United States with the number of uniform acts enacted. I think we were second last. Mississippi was last, and we had like 19. And now we are one of the top, maybe 2 or 3 uniform acts in the country, jurisdictions that have enacted uniform acts. And I think, again, I understand we inherited a mess from Congress when home rule was created in 1975. And this, the council has, very methodically improved the law of the district. And I think this is just part of that effort to give us a modern body of law that is the state-of-the-art law, and it's going to help the businesses and residents and make the district a great place to live and do business. So thank you again for your holding this hearing. I appreciate it.
Wonderful. Well, thank you so much, Chair McKay, for all of the work you and all those in the Uniform Law Commission do every day to bring some common sense and clarity and consistency to our laws in DC and across the country. We really appreciate your expertise and for pushing us forward in the right direction. So appreciate it. And thank you to my team for all of your efforts on these many, many bills that we discussed today. Really appreciate the big effort here. And with that, the time is 2:39 p.m. on Monday, June 17th.